University of Taiwan. And I'm really, really happy to share this panel with Wen Chen. We worked together previously within the International Association of Constitutional Law in some research projects. And it has always been a pleasure and also so interesting to listen her comments. And thank you very much to Wen Chen for being here. I'm Tania Groppio. I'm a professor at the University of Siena in Italy. Actually, at the moment, I'm in Siena, Italy. I'm professor of constitutional and public law. Then our panel will discuss some important and challenging issues related to human rights, especially related to environment, but not only to environmental protection and climate crisis. And they will deal also with the legal tools to protect those rights in time of crisis, in time of emergency. Unfortunately, in the era we are living in these days, and by focusing especially, not only, but especially on the role of courts, litigation and courts. We will have European, Latin American perspectives among the panelists, and we are lucky as the Asian perspective will be introduced by our commentator. Then I think that probably we should start at this point with the first paper that is going to be presented by two panelists, Marina Ferrer Carmo and Icaro Darion Núñez Ruiz. Marina Ferrer Carmo, she's from Brazil. She's a master degree candidate in France à l'Université Paris 1 Panthéon-Sorbonne. And Icaro Dario Núñez Ruiz is as well a master de candidate à l'Université de Paris Panthéon-Sorbonne. But he is from Chile. He's a research assistant there in Chile. Then I will give the floor to them. You know that you are going to share the 15 minutes. I don't know who would like to start. And thank you very much for being here. And I'm very interested in listening to your presentation. Thank you.
Thank you very much. Yes, you hear me?
Yes,
we can see me?
We can watch the presentation, and I'm sure we can also listen to you.
Okay, perfect. Thank you very much. Well, good evening, good morning and good evening to everyone. Thank you very much for having us here. Thank you for Professor Serna, Professor Groppio, Professor Wen Chen. I'm going to be presenting today with my colleague and friend, Marina. Our contribution is called Between the Right to an Unbalanced Environment and the Right to an Environment Free from Pollution, Receiving and Emerging Environmental Rights in Brazil and in Chile. Environmental human rights have been frequently described as an emerging category within contemporary constitutionalism. In Latin America, however, their constitutional recognition has been uneven and even sometimes in a counterintuitive trajectory. Brazil is commonly described as a paradigmatic case. It has an entire chapter on environmental protection, focused from a collective right perspective to an ecologically balanced environment. While Chile, on the other hand, is mainly the example of an individual right within an architecture that strongly protects property rights and economic freedoms. Yet these contrasting constitutional starting points have not produced parallel developments in Brazil. Early constitutional advances have increasingly been tested by legislative reforms and by political pressure, mainly since the election of the former president, Jair Bolsonaro, in 2018. In Chile, conversely, the constitutional moment that was opened by the social mobilizations of 2019 has been accompanied by a notable expansion in the judicial and legislative treatment of environmental protection, despite the rejection of the two successive constitutional reform projects. Against this background, we're going to be analyzing Brazil and Chilean cases, in particular the decisions of the highest courts in both countries, taking 2018 as a moment of political inflection in the two systems. And this paper argues something that is quite central, that is that the experiences of Chile and Brazil, and of the comparison of these two countries, reveal a shifting and asymmetric dynamic that complicates a linear narrative of emerging environmental rights. And rather than reflecting this simple opposition between something considered to be weak or strong, they reveal a shifting and asymmetric dynamics of expansion and constraint, shaped less by the constitutional text alone and more by the interpretation, the institutional design, and the political context of the country. Starting by the constitutional and institutional foundations, we have on one hand Brazil, that, as I mentioned, has an entire chapter dedicated to environment, and the Article 225 recognizes a collective right to an ecologically balanced environment with duties from the state and from society to protect the environment. And the Article 170 has integrates the environmental protection within the framework of the economic side of the Constitution. And from a more institutional perspective, is within this framework that the Supremo Tribunal Federal, the Supreme Federal Court of Brazil, occupies a central position. It is the guardian of the Constitution, and it exercises an hybrid system of constitutional review that is diffuse and abstract. In recent years, however, the Supremo Tribunal Federal has developed under a very intense political and economic pressure. On the other hand, Chile. The environmental framework of Chile, it's rooted in the 1980 constitution that was adopted under the authoritarian regime of Augusto Pinochet, and designed, as Professor Lovera clearly signals, to entrench a specific political economic model that is neoliberalism. Although it's quite early for Latin America in constitutionalizing environmental concerns, it did it quite narrowly, not with an entire chapter, but through the Article 19, number 8, which guarantees the right to live in an environment free from contamination or from pollution, assigning this to the state duties of impairment and to protect the preservation of nature, allowing statutory restrictions on other rights for specifically environmental purposes. Nevertheless, this clause in particular has been signaled by the doctrine as a sleeping clause that has not been activated by the doctrine historically. Institutionally speaking, in Chile, we have a dual mechanism of constitutional remedies, combining an ordinary judiciary, whose head is the Corte Suprema, the Supreme Court, with a constitutional court, that is the Tribunal Constitucional. Therefore, rights are mainly enforced via the protection claim, the recurso amparo, by the Supreme Court, while the Tribunal Constitucional reviews legislation. Traditionally, environmental disputes were channeled through the Corte Suprema, which expanded the standing and developed a denser reading of this Article 19, number 8. Nevertheless, after the protest of 2019, both higher courts have moved towards a more protective constitutional protection of the environment.
Hello, good evening, good morning. I'm Marina, and as my colleague Ícaro explained, Brazil and Chile have contrasting constitutional starting points, but as we're going to show in some parallels between the two countries, the two systems have moved in opposite directions. Chilean courts have progressively expanded the practical reach of environmental protection, while Brazil has, in key areas, accommodated forms of regression. We're going to talk right now about three elements, two regarding divergences in the country's jurisprudence and one regarding a convergence. The first divergence concerns the judicial treatment of environmental principles. In Brazil, where, as Ícaro said, environmental protection is already densely constitutionalized, the Supremo Tribunal Federal, the Supreme Court, judging the constitutionality of the new Forest Code, actively applied the principle of non-regression and declared some provisions unconstitutional. Nevertheless, in the same case, the court adopted a differential posture towards the legislator discretion and upheld most of the reform in benefiting the democratic legitimacy and the economic planning. This restrained approach has led some environmentalists to argue that the court provided an insufficient protection, weakening that non-regression principle and allowing some reductions in the core protection of essential ecosystems. In Chile, by contrast, the jurisprudence has expanded through the constitutional elevation of principles. The Tribunal Constitucional validated the precaution as constitutionally relevant, accepting action under scientific uncertainty and invoking an intergeneration dimension through a reference of future generations. This preventive orientation is reinforced by the Corte Suprema's use of sustainable development, judging that environmental protections is integrated into the social function of property, legitimizing ecological limits on ownership and economic activity. A second divergence is concerning the structural role of environmental rights. Em Brazil, the environmental rule of law, the Estado Democrático de Direito Socioambiental, is formally well established and supported by a broader access to judicial review. But it has operated under growing strain as the Congress and the policy choices have sought to dilute those constitutional safeguards. The constitutional litigation has therefore become a central tool against regression, placing the Supremo Tribunal Federal in a recurrent institutional confrontation against the Congress. While the court has sometimes invoked constitutional norms to curb backsliding, its effectiveness is constrained by political backlash, by strong agribusiness lobby, and the polarization of the environmental policy. In Chile, by contrast, recent jurisprudence has moved toward constructing an environmental rule of law through interpretation. The Tribunal Constitucional does this by recognizing environmental public order and reinforced constitutional protection, treating proceeding without required environmental authorization as a serious breach of environmental legal order. Completing this, the court also advances a systemic reading of the right to live in an environment free from pollution as both an individual and social right, but also as a duty of protection, positioning environmental norms as a core element of constitutional legality. The third comparison that we're going to make here concerns the emergence of new rights. In this particular case, the human right to water, where the two systems actually show convergent tendencies. In Brazil, the Supremo Tribunal Federal articulated a right-based approach while upholding the new sanitation framework and affirmed the access to potable water and adequate sanitation as a fundamental right derived from dignity, public health, and environmental protection, despite there is an absence in the Constitution of an explicit clause about the right to water. In Chile, in the same direction, the right to water has been grounded more directly in constitutional openness to international law. the Corte Suprema has treated international human instruments as binding and recognized the obligations to secure a minimum access, making the right to justiciable concrete duties imposed on public authorities. Those three comparisons we just made, taken together, they show that jurisprudential divergence that complicates the early expectations that we had when we read the text alone, the text of the Constitution alone. But we also need to mark some nuances and limits to that comparative framework, because in Brazil, for example, that apparent regression has been tempered by continued judicial enforcement of constitutional environmental guarantees, while in Chile, that jurisprudential expansion remains institutionally and politically fragile. In Brazil, even under conditions of intense political and economic pressure, the STF has not witnessed a wholesale abdication of environmental protection. Actually, in several emblematic decisions, as in the Amazon Funds or in the CONAMA reform, the Supremo Tribunal Federal has reaffirmed the binding force of the Article 225 of the 88 Constitution. This is particularly evident in the cases addressing the governmental omission during Jair Bolsonaro's administration. Taken together, these decisions, they show that any linear narrative is complicated to talk about environmental decline. They actually indicate that there are periods where STF has shown restraint, and there are periods that the court has not abandoned the constitutional foundations of environmental protection.
And regarding Chile, the expansion has been fragile without a formal entrenchment. As I mentioned before, the constitutional processes that came from 2019 and 2023 until 2023 didn't change the constitutional text. Therefore, the gains rest on the reinterpretation that higher jurisdictions have made and in ordinary law, which means that they're exposed to reversal through shifts on the constitutional or the judicial composition or on political pressure. And talking about political pressure, we have today a very different political context. The far-right leader, José Antonio Cast, was elected as president of the Republic and has begun his term in March 2016. And he's famous for having an hostile rhetoric towards environmental permitting and climate policy. And regarding environmental permitting, the last government, that was a progressive government, passed a law that is called Ley de Permisos Sectoriales that aims to streamline permitting times from 30 to 70%, potentially treating environmental procedures as obstacles rather than safeguards. Therefore, the expansion has been real, but it is precarious and it is politically contestable. As a conclusion, what we would like to say is that environmental rights, as we have been saying, this whole presentation, evolved through cycles of expansion and constraint, and they're really shaped by social and institutional context, not by only the text. The simple dichotomies of talking about a strong versus a weak constitutional environmentalism or an emerging and receding right fail to capture really the dynamics of environmental constitutionalism in Latin America. Thank you very much for your time and your attention. Muchas gracias.
E muito obrigada.
Thank you very much. And you respected also the time limit really in a very, very thorough way. And thank you again. And thank you also for introducing this comparison. And so many aspects and the relationship between the text, the written constitution, the interpretation, the political context. You also mentioned international law, different systems of constitutional adjudication. Then, there is a lot of food for thought and for further discussions. Then, thank you. And then I think now we can move to next speaker. It is Professor Valentina Capasso. I hope I'm right, I'm not wrong. I have just found some information, but she's a tenure track assistant professor at the University of Naples, Federico II, in civil procedural law. She's also working quite a lot on constitutional law, as far as I know. And then she's going to present this topic that is really intertwined between constitutional law and procedural law about climate litigation and the use of foreign precedents. That is exactly the topic when Chang and I worked have been working for many years in research on the use of foreign precedents. But the focus here will be on climate litigation and the use of foreign precedents in climate litigation, from cross-fertilization to cross-legitimation, question mark. Then Valentina, Professor Capasso, the floor is yours for 15 minutes. Thank you.
Thank you, Professor Groppi. I would like, first of all, to thank you, the International Association of Constitutional Law, for this forum, because it's an honor and a pleasure for me to be here, especially because I'm an outsider. I'm a procedural lawyer, but as Professor Groppi mentioned, I've always attempted to deepen my knowledge also in constitutional law, because it has always been my conviction that procedural law is nothing but applied constitutional law, and climate change litigation is perfectly demonstrate my point, especially the aspect I would like to talk about today. So I will try, first of all, to share my screen. I think that you are able to see my screen now. Thank you.
Yes.
So let's start. As Professor Groppi mentioned, the topic is climate change litigation and use of foreign precedent, because my question is if the use of foreign precedents may bring legitimization for judicial activism. So first of all, I should recall cross-fertilization as a phenomenon which has been long studied, especially when it comes to fundamental rights, which are, of course, for the vast majority, substantive rights. And from this angle, cross-fertilization has even been recognized by formal sources of law. Just mention, one may just mention Article 39, Paragraph 1 of the South African Constitution, which not only requires courts to consider international law principle, but also allows them to make reference to foreign constitutional jurisprudence when adjudication topics on fundamental rights. But when it comes to procedural matters, the topic is very less explored, even if it has already been noted that, especially for international and supranational courts, maybe procedural cross-fertilization is even easier than substantive cross-fertilization for a series of reasons, which spans from adjudicators' broad discretion over procedural matters to sociological factors like the fact that there is a very limited number of court personnel circulating across various adjudicating bodies. And all these reasons are brought to the raise of a sort of international due process. But it should be stressed that the phenomenon is not only known in international and supranational courts, it may be observed also in national courts. Suffice it to mention the recent trend for domestic courts, especially Supreme Court, to claim to have the power to set the temporal effect of their judgment, even if they are not vested of this power by internal domestic sources, but just recalling the power that other adjudicating bodies have or claim to have abroad. But from this angle, maybe it is better to talk about cross-legitimation than cross-fertilization, because the interpreter has the impression that reference to foreign precedent is not made in order to take inspiration, but in order to get a sort of recognition from other courts. And this calls to mind a famous quotation for procedural lawyers in Italy, a quotation from Nicola Picardi, according to which courts in general legitimize each other, finding in foreign precedents not only a source of inspiration, but also the support of the community. So this phenomenon, which is a phenomenon which goes beyond the national border, may be seen in particular in climate change litigation. We all know the famous Argenda case, which has been referred to by a lot of claimants throughout the world and consequently by a lot of courts. But just to take a more recent example, one may recall the Law Imgin versus Canada case, which has been adjudicated in 2025 by the Canadian Federal Court, which has assessed the value for Canadian system of the International Court of Justice advisory opinion on state obligation regarding climate change, issued in July 2025. In this opinion, as it is well known, the International Court of Justice set a series of obligations or duties for the state in order to prevent and mitigate the effects of climate change. And the Canadian court, albeit recognizing that the advisory opinion is of course not binding, allowed the claimant to amend their claim in order to include a common law tort based on customary international law, and stated that principle of international law may be invoked in domestic litigation. And this precedent stands in stark contrast with another recent precedent, this time a US one, Lighthizer versus Trump, which has been adjudicated by the US District Court for Montana, which has, by contrast, dismissed a challenge against some executive orders promoting fossil fuels. In that case, the US court has acknowledged that these kind of orders will worsen climate harms, but it concluded that it has no power to adjudicate this kind of claim against the government, and so directed the plaintiff to the political branch or the electorate. So we have two contrasting approaches to climate change litigation against the state. And this gave rise at least to one question. Can judges find legitimacy outside the state, outside the sources, the domestic sources of law, by invoking foreign precedents or international law? But then there is another question, because provided that they can find such a legitimation, is judicial activism the most appropriate solution? So I'll try to answer to this question very briefly. As to the first question, my short answer is maybe, but in the future. In order to justify this answer, we have to take a step back to the theory of sources of international law. Because under Article 38 of the International Court of Justice Statute, the sources of international law are both customary law and judicial decision, but there is no rule of binding precedent. And from this point of view, the situation is the same as in a lot of civil law systems which do not recognize the rule of binding precedent, exactly like Italy. And as for Italy, I have, albeit recognizing that there are no stare decisis rule, I have already tried to demonstrate that even case law, but not precedent, case law, so in its plurality, may become a source of law if it meets the customary law requirements, that is, consistent practice and the belief that the practice is legally required. But if one accepts this reasoning, I think that the same reasoning may be applied to international law, because also customary international law is made by state practice and opinio juris, so the belief that the practice is legally required. And my proposal seems to be confirmed by the International Law Commission draft conclusion on customary international law issued in 2018, which confirms that practice may include decision of national courts. So it is possible to imagine a sort of circle of legitimization by virtue of which a series of consistent rulings, and as far as we are concerned, a series of consistent rulings accepting that state court may condemn their own state for climate change responsibility, may give rise in a first time to a cross-fertilization phenomenon, but then this cross-fertilization would become a state practice, and then become customary law, and so will end up imposing on all courts, all international, all domestic courts, which are bound to apply international law. So maybe one day, not now, courts will be legitimate, judicial activism will be legitimate by international law. But this brings us to my second question. Would this be appropriate? From a strictly procedural point of view, it should be taken into account a great limit of condemnatory rulings. That is, condemnatory rulings against the state lack any coercive mechanism, so they would lack effectiveness. But my main point here, of course, is there is another problem which lies upstream. It's a constitutional problem, the problem of the balance of interest, because any kind of condemnatory rulings toward the state in order to comply with international obligation would end up modifying the regulation of economic activities. But it is self-evident that each economic activity involves other individual rights which cannot be simply sacrificed. And are judges capable and legitimate to do this kind of balance of interests? I'm doubtful about that, because as Gramsci wrote, a political leader, not a court leader, a political leader must possess enough general technical knowledge, and so has to make informative decision, but then he has to judge from a synthetic point of view because he has to make a balance of interest, while judges lack this kind of overview. And this would mean that the most correct jurisdictional solution may not be the best solution for the system, because the judges lack both the expertise and the broad perspective that legislature should have. Of course, these objections are not new, because they are the same objections that are longly been made against U.S. rulings in U.S. structural injunction. It is well known that the phenomenon of structural injunction gave rise in 1950s in the US with the famous decision in Brown versus Board of Education in 1954 and 55. But in the first time with the two Brown decision, the US Supreme Court decided to take a go slow approach. That is, it started desegregation of US schools, but just ordering the school to proceed with all the deliberate speed, so without directly intervening. This approach proved ineffective, so it was abandoned since 1971 with the Swan case, in which trial court personally decided to oversee desegregation with the help of an external consultant. And then in subsequent years, the phenomenon get traction and extended to other fields like prisons, mental hospitals, environmental protection too. But the debate is still there because there are a series of pros and cons for structural injunction. One of the pros is that in this way, the judiciary may hold institution accountable, but on the other hand, and this is the problem which is common to climate change litigation, that judges are not vested of the power to adjudicate this matter. In climate change litigation, however, there is another problem. So the problem is further complicated by the need to take into account expert witness evidence, which judges are incapable to assess. Actually, epistemological studies show that the correct approach is epistemic deference, that is, relying on expert judgment. But this would imply accepting the risk of expert error, and such a risk may be acceptable in private disputes, just like legal error, is less acceptable in disputes which aim to explain systemic effects. But in this kind of decision, there is another problem, a constitutional problem, that is the risk that political choice will shift from the legislature to the judiciary, and then to the expert, which has no democratic legitimacy nor accountability. And this problem is particularly shown by a recent order of the Turin Court, which decided to upheld the request for a series of residents of the city of Turin, which contested a municipal plan to fell a series of historical trees, because in that order, the judge decided not to block the municipal activity, but to direct it by giving specific detailed provisions declaratively based on the court-appointed expert suggestions. This is a kind of ruling which has been welcomed by scholars, but raise a question: can the administration balancing of interest be delegated to an expert witness? So since my time, I think, is up, my short conclusion is that one day maybe judicial activism in climate change would be legitimate. So judge could act in this way, in this field, but whether they should act is completely a different question. Thank you very much.
Thank you very much for your presentation. You also raised many important points, among them the same definition as of cross-fertilization, because it is partially a way to use foreign law, and the other way international law, and then this is always a challenging topic, and effectiveness of the judicial decisions, judicial activism, and the role of experts, and all of these relate to climate change. Then there are so many topics really here as well to be discussed, and when Chen will for sure introduce some comments, and probably also I would encourage later also the other speakers to ask questions or to make remarks once the Q&A question will be open. Then thank you. Thank you very much. Now we can move to next speaker. That is Luisa Shalhoub. Yeah, hi. And please correct me if I'm wrong, but as far as I know, Luisa Shalhoub is a PhD candidate in law at Masaryk University in the Czech Republic. And she has a degree, a master's degree in international law from Czech Republic as well, from Charles University. And is it correct?
Yes, it's
Good.
correct. Thank you.
And Luisa will present a paper focused on Brazil and international law. The title is Between Bridges and Gaps, Understanding the Brazilian International Protection Framework Amid Emerging Crises. And thank you, Luisa, for being here. And the floor is yours for 15 minutes.
Thank you so much. Thank you so much for this opportunity and for organizing this amazing event, which for me is a great opportunity to discuss my work. This presentation is part of my PhD thesis, one of the chapters. I'm comparing Brazil and the Czech Republic. So this is part of my studies, and I'm looking forward to having your feedback on that. I'm trying to share my screen. Can you see my screen or not yet? No?
Not yet.
Now it's possible?
Now we can see your screen. Yeah, okay. Now
Yes,
your
now you can see
PowerPoint
the
presentation is there. Okay.
Yes, okay, great, thank you. So this work is named Between Bridges and Gaps, Understanding the Brazilian International Protection Framework Amid Emerging Crises. So basically what I'm trying to understand here is more related to migration that could be applied for environmental displacement populations or other populations not covered by the typical concept of refugee. So I begin this presentation presenting the Brazilian's protection paradox, because while Brazil is lauded for his progressive migration and refugee laws, still it does not count with a comprehensive protection framework for forced displacement. Still, what we have in Brazil nowadays, and I'm going to show you in the next slide as well, it is the refugee law that, in fact, does implement the Cartagena broad definition of refugees, which is has enlarged the 1951 Convention concept of refugees, but still it lacks a comprehensive protection framework. And I argue that because according to migration governance framework in a global scale, and according with UNHCR and other international documents, for a complete protection framework for migrants and for people that are not only covered by refugee protection, we should have the refugee status. In parallel to that, we should have complementary protection for these people that also need international protection but fall outside the refugee definition. And lastly, we should also have temporary protection mechanisms, which are forms of mechanism to protect this population that could fall under refugee protection or complementary protection. But at the moment, because we are facing a crisis, an emergency situation, they cannot be activated, similar to the recent TPD activation for Ukrainians here in Europe. So while Brazil is lauded for his progressive framework, we can see there's this gap in the legislation. So the evolution of Brazilian legal framework and the key milestones in protection frameworks will show us how this gap was created. So first of all, the 88 Constitution, while the 88 Constitution is taken for a really democratic and human rights directive constitution, still it doesn't mention specifically refugees. Although it doesn't mention specifically refugees or any other sort of migrants, it specifically mentions foreigners. and attributes to them the same set of rights, or basically the same set of rights that Brazilians would have. So this democratic constitution laid down the groundwork for the refugee law. So in 1997, the Brazilian refugee law was enacted. In this law, it was recognized the broader concept of refugee, as we have in Cartagena Declaration, with enlarged the concept we have in the 51 Convention. Nevertheless, that was so far the only protection framework we had in Brazil until 2017. In 2017, we finally had the new migration law. This new migration law came really praised by the academics at the time because it switched the legislation we had before that was based on the dictatorship framework. So the new migration law establishes for the first time in Brazil a migration law that is aligned with the constitution principles of democracy and human rights. So after that, what we have now in 2017 onward is this framework that is based on human rights, but it still lacks some sort of protections. So when we look closely to the 88 Constitution, we can see that although fundamental rights are given to foreigners as well, only part of them are incorporated by the 97 refugee law, that the 2017 migration law still lacks some sort of comprehensive framework for this protection. And what we have now is still demonstrates this gap. Nevertheless, one good part of the new migration law was the institutionalization of humanitarian tools. So the humanitarian tools, they already existed in Brazil and they have been implemented since 2012. So in 2012, we had the first implementation of a humanitarian tool in Brazil that was applicable to Haitians following the earthquake in 2010. In 2013, it was also applicable for Syrians following the conflict. Then finally, in 2021, after already the new migration law, the humanitarian tools began to be applied following this new legal framework. So this policy was extended for Afghans in 2002 and to Ukrainians in 2002 as well. What is interesting here, and it was criticized at the time, is that while the humanitarian tools in Brazil, they can work as both entry visa and stays visas, they were allowed for Ukrainians as entry visas. So as they would need to apply for the humanitarian policy, for the humanitarian tool to arrive in Brazil. When it was not true, because Ukrainians, they are part from the visa-free entry in Brazil. So at the time, in the first 2 or 3 months of the war, it created kind of a misunderstanding and some overwhelming in the consulates, in Brazilian consulate in Ukraine. So what we have nowadays regarding humanitarian tools is that they work ambiguously. Because if we look back at this timeline of the use of humanitarian tools in Brazil, they were applied for people that would fall under the concept of refugees. So, analyzing a little bit more deeper the idea of humanitarian tools in Brazil, we can see that it actually has been used mainly for 2 reasons. Either to circumvent the application of refugee law. So, for example, when we had the case of the Haitians, there was at the time an impression that lots of them would arrive in Brazil. So we would have a mass influx of refugees in the country, which in the end didn't happen, but at the time that was the perception. So to avoid applying the concept of refugees for all of them, the humanitarian tools were used. And in another possibility of application of these humanitarian tools, they are to show Brazilian solidarity in cases of high trendy cases. So we can say, for example, the Syrians case, the Ukrainians case, we can see clearly that Brazil was not the main goal, the main destination for these populations, but still, as the rest of the world were showing their solidarity to these populations, Brazil also wanted to show this political side of the migration tools. So there are two criticisms, the biggest criticisms about those humanitarian tools as they are today in the Brazilian framework. The first one is related to the design, and the second one is related to the implementation. So relating to the design, one interesting aspect is that it mostly overlaps with the refugee definition. So humanitarian tools in Brazil have basically the same target population than the concept we have in Brazilian law and in Brazilian refugee law. And because they are overlapping, it risks weakening the refugee protection in Brazilian framework. Other than that, in terms of implementation, another critique that we have is that although the humanitarian approach that came with the Constitution made possible for the migration law to introduce humanitarian tools as a tool that's institutionalized in Brazil, not only through ad hoc mechanisms as it was being developing before, is still neither the migration law nor the implementing decree clarified how these humanitarian tools should be implemented. As a result of that, what we have today is that we do have a tool that is a statutory tool. Nevertheless, it cannot be implemented. It cannot be used without any sort of ad hoc mechanisms to do that. That's also defended that it would weaken the protection per se. So based on the first figure we saw in the first slide, we can now compare with the humanitarian tools in Brazil. So the humanitarian tools, they are placed in this ambiguous place because they are mostly closely with refugee protection, although they don't overlap fully. They do not grant the same set of rights. They are not as well complementary protection, which would be applicable for those who do not follow under the refugee protection, as they mostly overlap with the refugee concept. And they are nonetheless not a temporary mechanism protection as well, although it was applied similar to that, to the Haitian cases. We can see that its applicability diverges in other cases. So following that analysis, I have key gaps and conclusions to share. So my point here is basically that the lack of clarity in humanitarian tools, it will perpetuate this misunderstanding between entry and regularization tools that we have here in Latin America as a whole and in this case study in Brazil. So it weakens the protection frameworks. So I also argue that Brazil's protection system remains fragmented and characterized by precarious and case-specific arrangements rather than institutionalized structures, as the humanitarian tools, how it is designed and implemented today, does not allow for different treatment. I also argue that the new migration law has not yet addressed the normative and institutional gaps that we had even before its existence. So it still leaves essential dimensions of international protection insufficiently regulated. And by that, I want to mean the TPMs, the temporary protection mechanisms, and the complementary forms of protection. And I defend in the end that a comprehensive normative regime is needed for diverse forced migration situations, which could cover, for example, mass influx situations or environmentally displaced populations. And it would include the refugee status, the complementary protection, and the temporary protection as well. Thank you so much.
Thank you very much for introducing another emerging crisis that is related to migration, asylum seekers, and then you discussed humanitarian law, especially. Yeah, so interesting. Thank you very much again, and for sure we will have comments and questions for you as well. Well, next, then I think we can introduce our next speaker. That is also the last speaker for this session. Before the comments of the commentator, Francesco Luccherini. Francesco is postdoctoral fellow at the Department of Legal Studies of the University of Bologna. He will present a paper titled Arguing the Right to Environmental Transformation. And then we are back to the environmental crisis and the role of courts. Francesco, I can't see you.
Sure.
Okay, yes, now I can
Yes.
see you. You are somewhere there. Okay. And the floor is yours for 15 minutes. Thank you very much.
Thank you, Professor Groppi, and thank you for all the panelists, And yeah, we're back to the to environmental questions, but we are not really back actually, because I, compared to the first presentation by Marina and Icaro, I will take a much more abstract and theoretical approach, and I will focus on constitutional design. So Icaro and Marina closed their presentation by saying that text is important, but it's not all. So in this case, I will, I may say, stake on the importance of text in shaping specifically the economy. I have put together a very simple presentation, which you should be now able to see, hopefully, and there I proceed. So
yes,
first,
yes, we can see the presentation, although in
okay.
in that okay, now it's much
now
better.
It should be okay. Excellent. So when you know thinking about the proposal for this forum, so the idea of emerging human rights kind of triggered me, but at the same time it puzzled me to some extent, because a common theme in comparative constitutional studies is, you know, the excess of rights talk. So it's very easy, sometimes it may be easy to talk about new rights, but at the same time, the real challenge is to substantiate rights and to substantiate developments. So in the environmental sphere, obviously, we've seen it with climate litigation, with environmental adjudication, and everything that is happening. Obviously, the legal word, the legality and constitutionality, constitutional orders are changing and in facing ecological collapse and climate collapse, and so in facing environmental and ecological questions. There's been quite some emphasis on transformation, so transforming constitutional theory, transforming the rule of law, transforming fundamental rights with a view to weigh in the ecology and the environment, ecological integrity and environmental integrity. So what I'm trying to do today is to expand on the idea of environmental transformation and what this could actually be taken to mean from a constitutional design standpoint. So how should constitutions and constitutional political economy should be designed to weigh in environmental transformation? I should say that this presentation kind of joins together 3 papers of mine, one that is forthcoming sometime soon on the constitutional theory of sustainable development, a second one which is almost concluded on the circularity, so whether circular economy can be a viable, useful, or auspicable, desirable heuristic for a constitutional political economy, and the third one on environmental transformation broadly taken, so from a more political philosophical standpoint. I'm not okay. So again, very basic presentation. So what does it mean to argue for environmental transformation? So as a first point, the title is in itself a borrowing. So I'm borrowing from Louis Coetzee, who is a very renowned and famous constitutional theorist, environmental constitutional theorist, who in 2012, in the inaugural issue of Transnational Environmental Law, published this very famous paper arguing global environmental constitutionalism. So that was a paper that really triggered magnificent, really broad debates on environmental constitutional theory, what it should be taken to mean. So from a first standpoint, arguing the right to environmental transformation as a cartographic function. So from a descriptive standpoint, what I seek to do is to map out constitutional movements across the comparative spectrum with a view to infuse within them certain normative connotations, certain normative proclivities. Then the right to environmental transformation is also to be understood in deconstructed terms, meaning that there is no such thing in any national constitution as a right to environmental transformation, but this is a discursive device that I'm kind of proposing to understand the transformation of comparative constitutional law in the face of ecological and environmental collapse. Thirdly, obviously, the right to environmental transformation has a transformative connotation. And when we talk about transformative constitutionalism, the spectrum, the intellectual spectrum is really broad. So Karl Clare, in his original 1998 transformative constitutionalism essay on the South African Constitution, he proposed transformative constitutionalism on culturally relativist grounds. So transformative constitutionalism as the reinstatement of a specific, contextual legal culture, so on contextualist grounds. But some strands of the literature have actually critiqued Clare's view of transformative constitutionalism to kind of re-embed transformative constitutionalism within a more, I'd say, Dworkinian universalist constitutional theory. In the environmental sphere, my own account is that transformation has both substantive and procedural relevance. So from a substantive standpoint, constitutional environmental transformation, what it concerns is the active imagining of the transformation of the constitutional state in the face of ecological and environmental collapse. So how should the constitutional state and constitutional theory be rethought in order to have constitutional structures be relevant, I may say, attentive to what's happening at the level of climate and ecological collapse. From a procedural standpoint, instead, the discourse on the right to environmental transformation concerns the forms and modalities of transformation. And I approach this point on a procedure looking at what's happening with climate rulings, the International Court of Justice advisory opinion, the Inter-American Court of Human Rights advisory opinion, Klimasignorinen versus Switzerland, and the triplet of judgments on the 9th of April 2024 and the subsequent climate adjudication at the European Court of Human Rights. So basically, environmental transformation is actually unfolding and advancing via references to protective duties, which evoke positive rights. So the idea of public trust in the state, and so given protective duties, giving rise then to legislative duties, and on the other hand, due diligence requirements. So the claim is that from a procedural standpoint, environmental transformation at the constitutional level is happening following an inferential or derivative modality, meaning that a given principle is enshrined, a given principle is entrenched, and then the legislative framework is adapted institutionally via, obviously, parliamentary debate and political compromise too. Then, thinking about environmental transformation, when I think about how should the environmental constitutional state be thought of in 20 or 30 years' time, I have two main conceptual thresholds. On the one hand, a negative threshold on coinciding with liberalism, meaning that a lot of much political philosophy and much environmental political philosophy has been about eco-communism, eco-socialism, and degrowth theories, post-growth theories, post-growth with post-growth being something else. So on the one hand, my claim is that environmental transformation does, from a constitutional standpoint, does beg a question on liberalism, so on the preservation, on the safeguard of liberalism, meaning that, taking into account constitutionally, ecological environmental collapse should not come at the expense of sacrificing liberalism. On the other hand, I see a positive threshold in prosperity. So there is a general understanding that all international human rights law has developed following, societal quests for prosperity. So what in the Universal Declaration of Human Rights famously was framed as the decent standard of living, the continuous improvement of living standards. So my claim is that environmental constitutional theory should not, disregard prosperity as a crucial driver of environmental transformation. Then integrative connotation, this is a function of the fragmentation that we see at both the comparative constitutional law domain and in international environmental law, meaning that the right to environmental transformation and the idea of environmental transformation brings together a number of normative theories under a shared conceptual umbrella. Then, from a normative standpoint, so this was a description of what I take environmental transformation to be meaning. From a normative standpoint, my inquiry is into how constitutional political economy, or the economic constitution, so those parts of the constitution that shape the public governance of the economy, how those parts of the constitution should be refined and rethought to take into account ecological collapse and environmental collapse. And the two main questions that I bear in mind are these two. So how can environmental state theory be steered towards prosperity, but at the same time, how can the pursuit of prosperity be re-embedded within ecological integrity and planetary boundaries? Constitutional political economy, the economic constitution, a fundamental principle within comparative economic constitutions is economic neutrality, meaning that it is a shared tenet that constitutions within liberal democracies, within modern constitutional democracies, constitutions should not prescribe a specific order, a specific economic order, because the economic order should be subject to deliberations, should be subject to parliamentary compromise, and the economic order is, an historical contingency to some extent. The idea of economic neutrality has been fiercely defended by the Federal Constitutional Court of Germany, but it is also a shared conceptual and normative baseline in the International Covenant on Economic, Social, and Cultural Rights, and it is also structural to the principle of common but differentiated responsibilities. So the idea of common differentiated responsibilities, which is actually structural to the Paris Agreement displaces the question of political economy, meaning that the Paris Agreement does not engage directly political economy. Political economy is to be worked out domestically at the parliamentary level, but what should be pursued actively is, of course, the due diligence and the protective objectives and aims enshrined at the level of the Paris Agreement. So if on the one hand, economic neutrality is important because it is a function of economic liberalism, and economic liberalism, it is itself a function of basic commitments to human dignity, to liberty, and to equality. If on the one hand, economic neutrality is a necessity and something to be praised, on the other hand, unconstrained economic neutrality is liable to produce or to, I may say, propagate or to reiterate ecological collapse and environmental externality. So this is something to be rethought. How should this rethinking process from my own standpoint be channeled within constitutional design? I propose two main design baselines. On the one hand, the constitutionalization of planetary boundaries, meaning that constitutional political economies, so the ways national constitutions deal with political economy and the structuring of an economic order should feature planetary boundaries, meaning that any economic activity should be situated and located within the finiteness, the finite character of the ecology. And in this first paper of mine, which is forthcoming, I propose three main criteria to judge, I may say, to assess the appropriacy of constitutional designs of planetary boundaries, which are ecological assertiveness, hegemonic modulation, and conciseness. Ecological assertiveness, meaning that the Constitution should entrench a very thick baseline as to the meaning of ecological integrity. And in this, I draw from Klaus Bosselmann the idea of ecological Grundnorm. So the fact that planetary, I may say, planetary safety should be taken as a novel Kelsenian Grundnorm. Then a second criterion, hegemonic modulation, which deals with economic pluralism, so the indigenous communities' quest for for autonomy, for economic autonomy, economic self-organization, and conciseness, meaning sometimes from a constitutional design standpoint, less is more. So avoiding verbosity, avoiding very lengthy and very redundant formulations may come to the benefit of then the legislative and parliamentary working out of the issues. Second baseline, and with this I proceed to the conclusion of this presentation, circularity, which is the second paper I'm working on. And so the idea circular economy and the idea of circularity obviously is actually everywhere, especially in the area of business and private enterprises. Circular economy theory in itself actually is more an argument leaning towards a certain management of waste. So it deals more with waste than with political economy in itself. So there is a question whether circular economy contains, in its circular economy theory contains within itself a theory of the economy. My claim is that circularity, to put it simply, circularity should be constitutionally entrenched. And this second paper of mine will advance, I may say, proposals and possible formulations for the inclusion of circularity within constitutional political economy. But the constitutionalization of circularity should happen breeding circularity of growth normativity, meaning that constitutionalizing circularity should be kept at a distance from introducing a normative theory of economic growth in the Constitution. In this way, my claim is that circularity can work as a methodological heuristic, also at the level of constitutional interpretation, and eventually aid what I'm presenting today. So environmental transformation within the Constitution and under the Constitution. Thank you.
Thank you very much for this comprehensive presentation, Francesco. You touched upon so many important points, beginning from a transformative constitutionalism that is also an emerging topic and highly discussed. And thank you very much. Thank you. And I think, Wensen, now the floor is yours to comment the 4 papers. Thank you.
Thank you. Thank you, Tanya, and thank you all presenters. It's really my pleasure and privilege to read all 4 excellent papers and then having the opportunity to reflect and comment on all of them and each of them. So what I plan to do is that I would reflect first on a more general basis on the methodology, the studies and the focuses of constitutional law and comparative constitutional law studies today. And then I will move on to each of the papers with my specific comments and reflections. So I think the 4 papers studying on emerging human rights. So the focus has been on rights. But we know in today's study of constitutions, constitutional laws, and comparative constitutional laws, the study has been beyond rights. Rights study, rights focus is certainly still very important, and the derived doctrines, jurisprudence, and case laws. But we all know rights matter, but matter only to a certain extent. So the study of constitutional law and comparative constitutional law today has been already moved further to the study of context, as well as the study of institutions, and more importantly, the study of movements, right? So I think in Icaro and Marina's paper shows context also matters, right? You might have the same provisions and the same rights in the constitutions, but then you have very different developments, doctrine-wise, case law-wise, or even the consequences and the results, right? And the reason that you have different consequences, doctrines, and results might derive from the very different context, right? A developing country, a well-developed country, a market economy, and a relatively, a social, comprehensive, security-focused economy. So the context also matters. And today, we do hear a lot of comparative constitutional scholars or scholars talk about text and context. But I want to also address the 2 less focused aspects. One is institutions, the other is movements. So rights, doctrines, case laws, text, context also require institutions, either courts, but really beyond courts, business, market, independent institutions, governments, and the relation between the government and business sometimes also matters more than the text or even the context. So I think institutions are something that shouldn't be left out for constitutional studies. Also movements, you can have the same rights, the same provisions, the same constitutions, the same extent of developed economies in 2 countries. But when one has a very strong environmental movement, very strong public interest litigation, very strong civil society, and the other have very weak civil society, environmental lawyers and activists are jailed, are, suppressed. then you also have very different consequences or results or developments in these very two contexts or texts or jurisdictions where laws, constitutions, rights apparently have been similar. So I think I will urge all of you looking only not to text, context, but also institutions and movements. Particularly, this is important because we know all over the world today, courts are under pressure, right? We see a lot of constitutional backslidings, political backlash, political revenge against courts, right? And when courts are under pressure, then they have limited functions. They need to look out their own survival, right? And then when scholarship, particularly legal scholarship, focus only on rights, focus only on tests, we are actually pressure even more on courts because it premises courts to deliver the rights, to deliver the implementation of the rights. And then we also added further pressure of the courts vis-a-vis other political institutions, right? So that's something we need to bear in mind against today's, overwhelming constitutional backsliding, particularly the pressure on the courts. In our constitutional scholarship, should we add even more pressures to the courts? But perhaps I have not been fair, like, because when we have discourse on courts, when we have discourse on rights, well, courts are not the only one institution that can deliver rights, right? Political institutions also have something to do with rights implementations and rights discourse. Social movements also have a lot to do with the rights implementation and development and discourse and many other things. So I would encourage also, even when we talk about rights, we don't only expect courts or judiciary as the only institution that has been on the center of rights development, rights discourse, and rights implementation. We also need to look out institutions beyond courts, relations beyond rights-derived factors, and the movements, many other things to construct what rights can be extended. So that's the general matters. I want to just raise the flag for all of you and including me, and also for many of our constitutional scholars working in this field. Now, I would move on to each of the papers to give you my specific comment. First to Icaro and Marina, and for the wonderful comparative studies between Brazil and Chile in terms of how constitutional texts regarding rights have or have not delivered a strong environmental jurisprudence and strong environmental protection in terms of the institution and in reality. So, and then you provide really nice contrast where you have relatively strong constitutional provisions in environmental rights in Brazil, but then it's not delivering to a very strong environmental protection as a result. And then whereas you have a relatively weak constitutional provision in Chile, but then you have relatively strong environmental development and protection in reality. And you discuss this as perhaps context matters more, or at least to some extent. But you also show, well, at least in the right to water, there's some convergence. I just want to share the Asian experiences. So your finding is not surprising at all to me. So there has been consistent studies in terms of what we have in the Constitution. and what do we have or have not in the reality. So in East Asia or in Asia, South Korea and Taiwan had also, like Chile, relatively weak provisions in the Constitution. But then throughout institutions, as I emphasized already in the very beginning as my general remark, and throughout movement, both are very strong. So when you have strong institutions, when you have strong environmental movements and public interest litigation, even you have relatively weak constitutional provisions regarding rights, you also show some very strong environmental governance or protection, to say the least, in the reality. And then in South Asia, for example, most jurisdictions we have relatively strong provisions, lengthy provisions, many rights concerning environment in the Constitution. But it varies in India, in Nepal, in Sri Lanka. There may be a strong environmental litigation, but then not necessarily with strong extent of movement and strong extent of institutions. So I think your study is not surprising. What's I would and I think many constitutional scholars and environmental scholars or comparative constitutional scholars would like to look further to your study is then, okay, so now we see the gap, right? But what are really the dominating factors beyond the text and context, right? With because the democratic transition, for example, in Chile, that facilitated strong institutions or strong movement, and then they provide primary the factors to work through the relatively weak constitutional provisions to generate what we have seen today. And similarly in Brazil, right? Would it be because of the relatively weak civil society environmental movement, so that even if you have strong provisions, but that has not been worked out, or there are many other factors. And know that I also had a general reflection in the very beginning to say, well, this is the time when we see many backlash in many fronts, particularly the relation between the courts and political branches, the relationship between politics and economy, the relationship between civil society and businesses. So it might be also interesting for you to dig further to find the gap, the divergence that has been happening in Chile and in Brazil. Maybe it's the very beginning sign of backlash, or what? I think that would be something that we would really like to look forward to. And now I will move to the second paper by Valentina. And thank you so much. As Tanya mentioned in the very beginning, that Tanya, I joined Tanya's fantastic work for more than a decade, really producing 2 volumes, studying many national courts, and whether and to what extent and why and how they refer to foreign case law, foreign precedents in their judgments. Right? So your study provide a really interesting research for us to see further in this wave of climate litigation, both at the national courts, regional courts, and international courts. The reference to foreign judgments, foreign case law would have any difference at all. And so I would also perhaps ask you, and I'm also reflecting myself, because when Tanya and I, the big book, studying many jurisdictions, we really realize a pattern that in some jurisdictions, they like to refer many foreign case laws, and in others not. And for example, in Asia, again, East Asia, South Korea, Taiwan, Japan represent as typical jurisdictions that you don't see much reference, whereas South Asia, perhaps because of the colonization and common law influence, they refer to many case laws. But still, in East Asia, when South Korea, Taiwan, Japan, the courts seldom refer to other nations' case laws and judgments. Sometimes they will refer to, for example, European Court of Human Rights decisions. And sometimes they will refer to certain international court decisions. So and when they do so, certainly European Court of Human Rights decisions, European Court of Justice decisions have no binding effect whatsoever for these Asian jurisdictions, right? But in these jurisdictions, when they seldom referring to all these case laws, then the significant weight when they do so shows something, right? And we know in this wave of climate litigation, there are many decisions by national courts, by regional courts, by international courts. So I am also curious, and I am also very much looking forward to, are there any particular court's judgments being referred in this wave of growing climate litigation? The reason they being referred to more frequently than others, is it because they were decided first, or because they carry special weight in terms of the court's authority, or because they were really persuasive, right? So if we can study the pattern of referencing to all these different levels, international, regional, national, that will be very important for your study. And the second thing is that the function of making such references. We know climate litigation has also high bar, high threshold, and you are wonderful civil law, civil procedural law professor. In Asian jurisdictions, we have not heard many climate litigation, particularly in East Asia, because the civil law tradition making standing to sue, making the threshold to have a climate claimant, claim very difficult, right? So referring to all these foreign judgment, would that help they overcome this procedural threshold, procedural high bar, or it's just in the end they help some substantive arguments or not? So I think the function of those references, to overcome specific challenges, specific difficulties, specific threshold in the jurisdiction where the references were made is also very important, I think. IIJUNAM, for example, from the Netherlands, has been referred to by many subsequent courts, but they are not necessarily referred to in terms of their standing to sue procedural significance. Much more would be, I would say, the added function in terms of the substantive arguments, right? So from a civil procedural point of view, it's important. It's more important for the claimant, for the environmental victim, for climate victims to get into the court, or it's more important for once they were admitted to the court, then the substantive arguments, they have helped. So that's for Valentina's paper. And now moving on to the third paper, a different one, Louisa's paper discussing about the refugee rights. And I have to say, I enjoy reading so much, even though you complain or criticize, the ad hoc, temporary feature of the refugee rights or the situation in Czech Republic. But I want to share with you that in Taiwan or in many other Asian countries, those ad hoc program or those ad hoc or temporary arrangements are not exceptional, are not unusual at all. And then before reading your paper, I always think that, well, because in Taiwan, the reason we will have this kind of ad hoc arrangement is because Taiwan's special status. Some countries recognize us and would like to accept our help and are coming to Taiwan to receive some refugee protection, and others are not. And it's really because of this very peculiar political status that in Taiwan, we will have all these ad hoc basis programs for helping refugees or other internationally displaced persons. And then as a scholar and also as a human rights scholar, constitutional scholar, like you, I will always advocate for universal comprehensive programs. And I should note that Taiwan, we also have, despite all the efforts, we have not passed a refugee law, a comprehensive one, to the dismay of many, many scholars. So we always talk about, a comprehensive law and with all rights inclusive enshrined in that very law. And then we should also domestically incorporate the Refugee Convention and so on and so forth. But last year, when I talked to many human rights activists, those special organizations helping the refugees or the international displaced persons like the Ukrainians. So in my university, we also have a few Ukrainian researchers, students, those from Tibet, and then those from Myanmar, for example. And then I realized that there's, to my surprise, perhaps I should say so, the ad hoc programs have not been seen as really hostile. To the contrary, they can be tailored to the special needs of a certain refugees or international displaced persons from their home countries and to Taiwan. The needs are different. And so the ad hoc programs can function as a specially designed for some group for a certain time. If looking this way, I think it's also with some scholarly importance to study, not entirely from the negative point of view, but some functioning point of view about how these ad hoc programs work or not work in the reality, right? So is it because, for example, in Taiwan, even though it's just ad hoc program, but as I mentioned, the movement, the institutions, and because they are very strong refugee human rights organizations and group in Taiwan, and they work with these special agencies that is capable of developing ad hoc programs. Ad hoc programs, in the end, turn out to be very much tailored to the needs. That might not be necessarily good in reflecting from a very comprehensive law, right? So I just want to give you this example to say, well, beyond criticizing the lack of the law or the lack of a comprehensive system, it might be also helpful to study what kind of ad hoc program or what kind of ad hoc project can be catering to the special needs, and they might be functioning well to certain specific groups or contexts, for example. So that's my comments to the third paper. I might be running out of time, so I will go very quickly to the last
it's fine.
challenging paper.
It's fine.
I'm still fine.
Yes,
Thank
yes.
you.
Thank you.
Thank you, Tanya. The last paper, arguing the right to environmental transformation, I think it's a very ambitious conceptual paper. And then again, now knowing Francisco that this is the third in the row and you are already developing the first two, I would just complement to what I say in the very beginning, that rights discourse should not be only tailored to the courts. And I understand you developed this conceptualization of right to environmental transformation for constitutional design. But certainly, you also need to have that in mind. Once you have this in the Constitution, which institution will be your primary interpreter of that rights, right? And you interpret this rights as a very thick rights that is capable of have, you know, the ecological dimension and then have circularity into it. And will courts be the suitable institutions to implement this very conceptually grand, thick, and challenging rights? So if not, and we know there's risk of shouldering for the courts to shouldering too much, right? So then in the very beginning of constitutional design, you might want to also clearly think through. So if you have this very thick, argued, designed rights, so what institution underpinnings you need to have? For example, circularity, right? In order for circularity to be the basis or part of the right to environmental transformation, I would imagine you certainly require effective governance and certain strong institutions, right? So if you include these other actors, framework, forces, movements into this very thick right of environmental transportation, I think it will be more convincing, and people will not be worried that, well, we have this very thick right in the Constitution, but what come afterwards? Which institution is going to be the primary force for implement that? And how can we be really sure that this very thick articulation or conceptualization of right would be really capable of, say, dealing with the challenge of the type of economy, right? Market economy, business, development, you know, and this very thick right, which political institutions, elections, political parties, can they really utilize such right to deal with, say, the developmental state? For example, the AI, right, which suck all this electricity, suck all the energies of the very existence of human beings, and including states and the society, right? So I think the very thick conceptualization of rights require also at least some extent of articulation of institutions, agencies, frameworks, and forces and movement, if not equally full articulation of all these things. So I think these will be all I have for now, for all wonderful papers, which are enlightening and stimulating. Thank you, Tanya.
Thank you very much, Wen-Chen, for your comments. I think that now probably what I'm going to do is to give the floor to all the presenters to react to your comments. Then I would like to start because I already raised his hand. Probably we can follow in inverted order. We can start from the last speaker, Francesco Luccherini, that raised his hand, and then move to Luisa, and then Valentina, and Marina, and Icaro. If you agree, I would like to ask Francesco to quickly
Yes.
react to the comments for a couple of minutes.
Yes,
Thank you.
so I just wanted to thank Professor Chang for actually drawing a few very on-point, spot-on critiques. I just wanted perhaps to clarify my approach, because I know that in academic discourse and in academic conversation, when a project is ambitious, it has some connotations, right? Meaning that perhaps you're doing too much, or like your perspective is too macroscopic, and this obviously draws in what Professor Chang, I mean, the beginning of Professor Chang's talk on contextualism, which is one of the themes that is crucial to comparative constitutional studies. So what I wanted to specify is that I am not presenting the case for the right to environmental transformation as, as a panacea, as, a solve-it-all kind of solution. And I do have rightly in mind, the institutional, political, and also social movements variables that are embroiled in environmental governance. My difficulty, but also my challenge was to have these 3 papers which deal with sustainable development, circularity, and climate denialism, so ecological populism. And my challenge was, can I draw a single provocative narrative and present it before the International Association of Constitutional Law Forum? So just wanted to flag and perhaps to kind of detail the fact that the right to environmental transformation was meant to be a provocation, was not meant to, I was not meaning to present a case for the inclusion of a new human right. Actually, quite to the opposite. My idea was to kind of show or to raise the untenability of new human rights discourse in the environmental sphere. And I just wanted to add one more thing, and then I'll pass the floor to the next speaker. My own view of environmental transformation and transformative constitutionalism in the environmental sphere actually aligns with Lulu Weiss' approach. Lulu Weiss in 2019, she published a paper in the International Journal of Constitutional Law, where she presents environmental transformation as a legislative model of environmental transformation, meaning that in her view, which I kind of adopt and further and endorse, the Constitution should kind of entrench legislative mandates, legislation requirements. Then it will be up to the, to the parliamentary level, so the institutional level, to work out the details, and that in turn begs the question of political aggregation, social movement, and political compromise too. That is all.
Thank you, Francesco, for your reaction. Thank you. And now, Luisa, would you like to react, to add something, please?
Yes, thank you so much. Thank you so much for your comment. It's amazingly valuable, and I totally agree. I think I should phrase it differently in my thesis, and also in this paper that I'm writing, which is part of my thesis, because in fact ad hoc mechanisms, they can have a value application in refugee law and international law migration. I guess my point here was more because my thesis, while this paper is going to be broader, my thesis is more focused on mass influx. And for mass influx situations, it would be more challenging to implement ad hoc mechanisms that would be tailored. And of course, once they are more specific, they are probably more effective, but still it would be challenging mass influx situations. But definitely this is something that I should take into consideration, because I'm mentioning that in my thesis when I talk about the alternative pathways, which is the UNHCR, yes, let's say new sort of long-term solutions or suggestions for long-term solutions. So, but it really opened my mind that I might be following also a more positivist approach in terms of international protection, while I could open it a little bit for alternative propositions. But yeah, no, I just wanted to clarify that actually for my thesis, from where this idea from the paper came for mass influx situations. And then I would like to ask you a following up question. If you think that in case of mass influx, it would also be interesting, or if we should try to rely on that on other cases, because I understand that the example you gave from Ukrainians, and also if it were Ukrainians in Brazil, it would also be interesting to apply ad hoc. But in other cases, it would be interesting to have your view as well. Thank you so much.
Thank you. Wen-Chen, would you like to quickly react? We are allowed to have 5 extra minutes just in case we would need. I don't know if you would like
Let
to.
me do in the end. Let's have
Okay, good.
the
Better. Yes,
presenters'
better.
responses, and then
Yes,
I will do that in the end.
Very well. Thank you. Good idea. Then Valentina, please.
So thank you, Professor Chen Chang, for your highlights. As to the first one, I cannot give you an answer because it requires empirical studies, of course, as to the use of foreign presidents in this field. But from a theoretical point of view, just an immediate reaction may be that, of course, each court has may be more or less keen to use foreign presidents in general. But in this specific field, since it's an emerging field, it is the primary act for the claimant to refer to presidents, because normally there are no presidents in their jurisdiction. So in some way, each court is forced to deal with other presidents, foreign presidents. It may be more or less keen to respond. Even this also depends on the stilus curiae of the court, of course, if they have an obligation to give an extensive reasoning in upholding or dismissing the claim. But I think that in this field in particular, there is a strong external force to using foreign president. So, but of course, I will explore this topic further with an empirical research. This is in some way linked to your second point, because what is at stake now, it's more procedural rights or the substantive right. Actually, I think that especially for jurisdiction like Italy, where we have some, as you surely know, our constitution has enshrined 2 kinds of subjective legal position, the right and the legitimate interest. And so the first step in order to have a judgment on the merits is to demonstrate that we have a right. So the matter of justiciability and standing are strictly interconnected with the merits. And this is not by chance that our first judgment, which is not a judgment by our Supreme Court, so this kind of judgment may be revised, but the judgment rendered by the Rome trial court in the last judgment case was a dismissal judgment on the ground of absolute lack of jurisdiction, which for a foreign point of view may be a lack of justiciability, but for us is also a judgment on standing, because saying that there is an absolute lack of jurisdiction means that there are no legal subjective position at all to be enforced before the court. So I think that at present, this is the most important thing to demonstrate. And so the use of foreign precedent by the claimants, first of all, and then the use and the confrontation with the foreign precedent is in order to establish if we can go before the court. And then, of course, once this issue has been resolved in an affirmative manner, which is not granted, then foreign precedent may be used also in order to assess exactly the content of this right, if it is a right. Thank you.
Thank you, Valentina, and then Icaro and Marina, please.
Yes, well, thank you very much. Yes.
Yes.
Thank you very much, Professor Wenchen Chang, for your comments. Actually, the idea of this contribution was born in a seminar of comparative law led by Professor Marie Gren, and the idea was that we thought about the dominant accounts in these evolutions, differentiated evolutions. We could say a progression and a regression was the opening that a more conservative cycle that the election of former President Jair Bolsonaro opened in Brazil, while in Chile we have a more progressive coded cycle between 2019 and 2023. All of this beyond the regional tendency of the recognition of the human right to water by the Corte Interamericana de Derechos Humanos in 2020. So thank you very much. I would like to also know if we can interact or make questions to other people within this forum, because I am...
Yes, we don't have a lot of time left, but you can raise a quick question.
A very short question. I would like to know why regarding the environmental transformation, why to phrase it as the right to, and not just environmental transformation? Why to phrase it in use fundamental language and not just transformation? That's it.
Thank you very much.
You?
Thank you very much.
Please, Marina, you don't have, no, you don't
No,
want to add?
We agreed that we would say only fast one only speech, but thank you very much.
Thank you. Then the question was to Francesco, I suppose.
Yes.
And Francesco, if you would like to react quickly before giving the floor for the final say to Wenchen.
Sure. Thank you, Icaro. So the idea, again, so this was actually the rights framing was a provocation in its own right, meaning that I do not believe there is a right to an environmental transformation, but my claim is that from a descriptive standpoint, legal entitlements, which are transformative in nature because they kind of accrue within a framework of a progressive framework of due diligence requirements, either due diligence requirements or protective duties. So there is no right to environmental transformation from a constitutional standpoint, but there is, a very important and very thick emergence of legal entitlements, practical legal entitlements, narrow practical legal entitlements, which if looked together, if put together and looked at them from a macroscopic, macro constitutional standpoint, they do have a transformative connotation. And so this descriptive claim then raises the question. So this is the, how may I say, the bottom-up data. So the bottom-up element is that legal entitlements which have a transformative connotation are emerging, in courts, in parliaments, in constitutions. But this raises then the normative inquiry, which is the top to bottom approach. So how should we also rethink constitutions and specifically constitutional political economy to ensure that the two processes, the bottom up and the top to bottom processes, are mutually beneficial and they intersect with each other. This may sound abstract, but this is how I see it.
Thank you. Unfortunately, we ran out of time. Then we don't have time for more discussion between us here. But just for a final say of Wen-Chen.
Okay, so I will be very quick. So to Louisa's question, so the honest answer is I don't know. So again, so in Taiwan, so the NGO reported, for example, I said we have displaced person from Ukraine, right? And their special needs is to be integrated into our universities and science hub for a certain period of time, right? So the stay permit or any other more formative arrangements was not necessarily their need. But in contrast, for example, the displaced person from Tibet, from Hong Kong, from Myanmar, right? So they are not necessarily integrated to our universities and science sectors, but they are more to the ordinary housing, business job, and all that. So really from my experience of learning through these NGOs who are really from the bottom up level to help them, I realized that ad hoc programs are not necessarily bad to our usual, scholarly point of view. But still, I am still the advocate for, a more comprehensive systematic regime. But I just then, from that experience, value the ad hoc programs. And I think since then, I have a different view of what that kind of comprehensive law should include, right? Perhaps they should include these kind of empowering mechanisms to cater the needs. That's what and then more dialogue. And then rather than the top-down usual refugee law with agencies, all the powers. I think that's really where my view has been changed by those more recent dynamics in the internationally displaced person in Taiwan. And the last word to Francesco. No, now I know better. Like you sort of conceptualize this right as a provocation, but I think Icaro and Marina have rightly to ask, and as I suggest, rights can be a structural rights, and right can be governance rights. Right can be also understood as a procedural one or substantive one. So in the study of constitutional law, comparative law, we used to only understand right as a thin, thick, conceptual as a plan. But I think the new era or the new challenges should enable us to think about rights in different sort of mirrored ways. Then I think your contribution would not only be just provocation, that might and then last word. So Luai's proposal, I'm very familiar, but just to provide you empirical study or research in East Asia, the legislative mandate can go very wrong, because the parliament, they are very much catering to economic developments. And so the kind of negotiations, structures that you can have through legislative mandate by constitutional framework or environmental rights can be poorly implemented. But that is not to say then we trust back again to the courts. That's why I mentioned earlier, today, all constitutional lawyers should have some more creativities, right? So we should think about different institutions, and different agencies. As I said, in the refugee work in Taiwan, right? Surprisingly, NGO actually works much better and much catering to the needs of those displaced persons than the single agency or than the courts, right? And so I think the reconceptualization or any conceptualization of new rights should also have this kind of different transformative institutions or forces or frameworks in mind, even we don't have the vocabulary now. So I want to just say as an encouragement rather than discouragement for Francisco to develop this very challenging thing. So that will be for all. I know time's always not enough, but thank you all for 4 wonderful papers. I wish to write the Asian counterparts of all of that.
I'm happy that I phrased criticism, because that was the intention behind the provocation. And so thank you.
Yes, thank you so much to all of you. Thank you to Wen-Chen for the wonderful comments. And I really think that we need an extra dose of creativity. This is what we really need, to be creative, because we need to find new solutions. And then we cannot just rely on the categories that we are used to, because they are useless at the moment. Then we need to channel those forces that exist within the society. When Chen mentioned movements and then the private actors, we really need to find a way to channel in order to have them to implement and to protect rights. That is finally the goal we have as constitutional scholars. Then thank you again. I would like just to remind all of you that the next session will be on the 20th of March, panel 7, same time as this panel, 8 a.m. in Mexico City. And then you should double check the time zone. It will be a session in Spanish related to the topics we discussed today. It will be on environmental protection and constitutional law, medio ambiente y derecho constitucional. Thank you very much to the IACL, to Professor Serna, for organizing this wonderful forum. It was a pleasure to spend the 2 hours with you. Thank you. Goodbye, and hope to see all of you in Bogota in July for the World Congress. Bye-bye.
Thank you
very much.
Thank
Take care.
you. Thank you. Bye-bye.
Bye.
Thank you
Bye.
very much.
Bye. Good night.